Alright, what do you need to know about entering the Chinese market? Some of you are lawyers and associates, so it's what your client needs to know. Rule number 1 is first to file rule as opposed to first to use. Okay, what the first to file rule is for trademark law is that the person who has registered their mark first in the IP office of the relevant country has prior rights compared to the person who uses the mark first. Now, for trademark law, it varies from country to country, and the first to file rule has some pros. See, if you are the first to approach the IP office and protect your trademark, it's arguable that the reason for the early registration should give you prior rights, because this is easy to manage trademarks. Every record that's recorded in the IP office will be the basis to identify who is the true owner when there is a dispute at a later on using the same mark for identical or similar goods and services. So when ownership is recorded, it's very clear. Take, for example, the ownership of a property, landed property. The title deed clearly identifies who's the true owner of the property. Similar to that, having a trademark registered and having it recorded legally is a clear identification of who's the true owner. Trademark searches are also absolutely clear, because once you do a search, you can identify who are the prior owners of the mark. There wouldn't be any misleading or any ambiguity as who's the owner if they've been using it first. Because to find out who has been using the mark first in the market is actually a very difficult task. You will have to do a market survey, get investigators involved, and it will take time, effort, and cost. And freedom to operate opinions as well are very accurate. So there are pros in relation to the first to file rule. And these are the pros. And as many of you are probably thinking, especially if you're brand owners yourself, the cons are large, even though it's just one. The main con being it can be unjust to the prior user. Prior user of the mark, if he or she was not aware that he or she was not aware that they had to file the trademark first, and they had built a lot of goodwill and reputation by using the mark extensively in that market, they would lose out in this first to file rule. So it can be extremely unjust to a prior user. Well, China unfortunately has the first to file rule. So the very key thing that you need to know, or you need your client to know, is that the China IP office recognizes the first to file principle. So what does that mean in relation to your business? Is that if you foresee your company entering the Chinese market, you should immediately take action to file the application and pursue the prosecution of the application until registration. Now, this is very different from your trademark protection in other countries, where it's the first to use. You might test the market first, see whether you actually have a successful business, then put in some investment to register your trademark. Or you could even start applying for the trademark when you foresee yourself entering into the market in the next 6 months. Now, with China, even 6 months is insufficient. If you foresee that you will definitely enter the Chinese market within the next 1 to 5 years, then you should immediately take action to file the application. So that's rule number 1 in China. Now, well-known marks enjoy special rules.
At my website, you'll find online financial seminars, which is I call webinars. I do it regularly, and also a lot of online investment and financial courses, which is conducted solely online. So I'll be waiting for you at my website at kclau.com. I wish you have a great day. Hope to see you soon. Bye bye.